ghost came up and cut his tether off.
I'm not an expert on ghosts, so I can't.
My client reports that his bag was stolen from him. He had no way to charge his devices. The charger was in that bag. My understanding is that the device was then cut from his leg. I don't know that my client would admit to doing that himself or that someone else did that on his behalf. However, like I stated,
What?
Mr. Green, will you please name for records? State that a little louder.
Cedric Green. All right.
There's none yet. He told me I should talk to them over the next week or so via email so I can see about getting one. Your Honor, with regard to these cases, we are going to be asking to set all three matters for preliminary exam at this time. In the interim, for my client's sake, and for the record, I will be working with Mr. Cook as well as Mr. Vangalo in the circuit court to attempt to get him some sort of offer going up.
Got it. All right. Discovery is complete on these cases.
To the best of my knowledge, Your Honor.
Are there witnesses available the 7th?
Your best, Your Honor.
Preliminary examination in these cases will be set for April 7th, 2026, 9 a.m. before Judge Perry.
And then, Your Honor, as to the bond violation, I have had an opportunity to discuss that with my client. I'm working on that right now. With regard to the violation, Your Honor, it's my understanding that my client would be admitting to the violation. However, somewhat of an explanation here, and I would be asking to address bond.
I don't have my copy of it. Oh, there it is. Okay. Yes, go ahead.
With regard to an explanation, Your Honor, my client reports that his bag was stolen from him. He had no way to charge his devices. The charger was in that bag. My understanding is that the device was then cut from his leg. I don't know that my client would admit to doing that himself or that someone else did that on his behalf. However, like I stated.
What? So this is part of the explanation?
This is part of the explanation, Your Honor.
Grab his leg and cut it off? Okay. Go ahead.
He advises that he advises that he was scared at the time, that he wasn't in his right frame of mind, and that he wasn't also on his medications. And he advises that he was getting high, Your Honor.
Yeah, what?
Getting high, Your Honor. And in that regard, like I stated, Your Honor, I would ask to address the bond.
Motion for bond reduction is denied. Defendant admitting to the violation. I will sentence him what was stated in the violation. On the violation, I'll sentence him to 7 days, credit 7 days served.
And Your Honor, would the court be willing to consider a release to an inpatient treatment or
Send the order? No, I don't think there'll be a problem, is there?
Your Honor, for the record, the people would have an objection to that, given that he was cutting off his tether. I have concerns that release to treatment, even with the tether order, that would not be sufficient.
But if he's treatment, he's probably not getting high, which is probably part of the reason that the ghost came up and cut his tether off.
I'm not an expert on ghosts, so I can't say that, but
It was scared or something. I will sign an order.
Okay, thank you very much.
This exchange reveals exactly why the defense's explanation failed as a bond argument. The defendant admits the violation, acknowledges getting high, and offers an account in which his bag was stolen and the tether was somehow cut from his leg without clearly accepting responsibility for who actually removed it. Judge Simpson's sarcastic reference to a ghost exposes the credibility problem. The court is being asked to believe circumstances that do not square neatly with the admitted violation. Did you notice how quickly the bond reduction request disappeared once drug use entered the record? But there is an important distinction in the judge's response. He sentences the defendant to 7 days with 7 days of credit, yet remains willing to sign an order involving inpatient treatment. That suggests the court is separating accountability from rehabilitation. Treatment may address the behavior contributing to the violation, but it does not erase the violation itself. Strategically, defense counsel salvages something valuable here by pivoting from immediate release towards structured treatment. The question going forward is whether treatment can provide enough supervision to overcome the court's obvious concerns about compliance.
People on both cases.
Good afternoon, or good morning, Your Honor. Marcia Cracher on behalf of Ms. Sanders.
What?
Good morning, Your Honor.
Oh.
I'm excited.
Out there, you explored the world, thought the place was better than Washtenaw County, and you're back.
Yeah, it was a long journey, Your Honor. But I'm glad to be back. I'm so happy to be back.
It's like Groundhog Day. It's just going to repeat itself.
Hi.
Well, it's good to have you back.
Thank you.
Your name, ma'am?
Chardonnay Sanders.
Thank you. You need an adjournment?
Yes, please, Your Honor, to making sure I have all discovery and then to share that discovery with my client. Additionally, my client is.
The 9th work for you?
I'm sorry?
The 9th work for you?
Yes, it will, Your Honor.
Probable cause conference will be adjourned April 9th, 2026, 9 a.m. Bond.
Well, my client's asking me to make a bond modification argument, Your Honor.
Okay, go for it.
Okay, thank you. My client's currently charged with 2 cases that are very serious. She understands that, but those are allegations. She'd like me to relay to the court that she's lived in this county her entire life. She has some children that she needs to ensure that are being taken care of. During this time, she has been working on her case service plan for her neglect and abuse case, and she's doing well. She does not have a job at this time, so the bond amount that in each case is a financial hardship for her. She's willing to do a GPS tether. She understands that she needs to come back to court, and she has family in the area that she could stay with and support. So we're asking to lower the amount to a PR if possible and or a 10% component, Your Honor. Thank you.
Front from the people.
And I would ask Bonnie saying she felt over here on the child abuse case and this court. Second charge, she got picked up and she was here before you was assault, pretty probably harm, lesson murder. She allegedly stabbed her mother's girlfriend in the arm, causing a lot of damage.
My client tells me that she had her cell phone stolen from her, and that's why she missed her court date, Your Honor.
Okay. Thanks for letting us know. Given all those circumstances, I'm not going to reduce her bond. Her examination is coming up, and we can certainly address it at that point in time after the testimony is heard. Motion for bond reduction is denied.
Thank you, Your Honor.
Your name, sir?
Deontay Jones.
Thank you.
Your Honor, I was just appointed to this matter. I do not have any body cam or video footage, which I'd be requesting, so I'd be asking for adjournment.
April 9th? Okay. I'll adjourn this to April 9th, 2026, 9 a.m. That's the bond.
These, the defendant's law has clearly said that 45 family with a 10% provision. At this point, I'm going to be requesting our original request of $50,000 cash charity. Mr. Jones, since being arraigned on March 15th, has made 192 calls completed to the victim.
192.
And I suspect that number may have grown since yesterday because that was when the most recent set of calls has happened. We've been having a hard time keeping up with the amount of calls that he's been making. So at this point, I'm going to be re-requesting our original request. This case is also occurred when Mr. Jones was on probation out of the 22nd Circuit Court for domestic violence for different victims, along with larceny in the building. And at this point, I have concerns given that he's made this significant number of calls to the victims from his PIN to her listed number. And I'm going to be requesting our $50,000 cash charity original request along with his phone and text privileges being revoked to be asking the judge to block her number as well.
The short response, Your Honor. What I hear are a number of calls, but I don't hear any of the substance of what those calls are about. So I certainly would be asking that court would at least temporarily stop his.
That he's not supposed to have contact at all. It doesn't matter what he's talking, really. But go ahead, I'm sorry.
No, that's understood. I would like to get a copy.
This is the critical legal turning point. Defense counsel tries to shift attention from the number of calls, 192, to their substance, essentially arguing that the court should know what was said before treating the conduct as justification for a major bond increase. Ordinarily, context can matter enormously, but Judge Simpson immediately identifies the weakness in that strategy. If the bond condition prohibits contact altogether, the prosecution does not need inflammatory conversations to establish the compliance problem. The calls themselves become the issue. And there is another damaging factor. The prosecutor says Jones was already on probation in a domestic violence matter. Judge Simpson later emphasizes that history when assessing whether Jones understood the significance of bond conditions. That turns this from an argument about misunderstanding into one about repeated disregard for court-imposed restrictions. Would hearing the recordings change your view, or are 192 calls enough once no contact is required? Defense counsel's fallback, remove phone privileges but leave the existing bond intact, is strategically sensible because it proposes a targeted restriction. But the prosecution is arguing something broader. The sheer volume of alleged contact demonstrates that lesser restrictions have not produced compliance.
Be able to review them prior to addressing them further, but I think taking away his phone privileges is enough rather than raising his bond.
That's a significant amount of calls, a significant amount of connected calls. And the very fact that he's on probation on a DV, he understands, certainly understands what his bond conditions would be regardless.
Mm-hmm.
I think he would have more of an understanding of it. I'm going to grant the people's motion. I'm going to defendant's bond is reset at $50,000 cash surety. We'll get the message. And also his phone privileges as well as texting privileges are hereby ordered revoked.
Judge Simpson ultimately grants the prosecution's request and resets Jones's bond at $50,000 cash while also restricting his phone and texting privileges. The reasoning becomes much clearer when you look at the hearing as a compliance assessment rather than a determination of guilt. The underlying criminal allegations have not been proven at this stage, but bond conditions are court orders, and the prosecution presented an allegation of 192 calls to the victim despite a no-contact restriction. Judge Simpson's point is straightforward. When contact itself is prohibited, the content of those conversations is not the only issue. The defense did identify a legitimate evidentiary question by asking to review what was actually said, and counsel proposed the narrower remedy of removing communication privileges instead of increasing bond. But that argument collided with the court's concern about whether Jones could be trusted to follow conditions at all. His existing probation status further influenced Judge Simpson's assessment that he should understand the consequences of violating restrictions. Across these hearings, the recurring lesson is that credibility and compliance can dramatically shape pretrial decisions. Treatment proposals, financial hardship, family connections, or narrower restrictions may all support a defense request, but they become much harder to sell when the court believes its previous orders have been ignored. Do you think $50,000 cash was justified here, or were the communication restrictions alone sufficient? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.